Hi everybody, Dana Sparks, broker of Maximum One Greater Atlanta Realtors. And today's contract tip, we are continuing on with the changes that the Georgia Association of Realtors, GAR, has made to the contract package for 2021. So please, I will link below the other videos I have done on this topic. And I am the director of the Georgia Real Estate Academy, and we do teach a 3-hour CE class on this topic called 2021 GAR contract changes. And I'll put the link to the online calendar below. It is a free class. It is virtual. We are teaching it throughout January, so it is open to all agents in all of Georgia. So please check out the link and feel free to register for the class. So today, as I mentioned, the majority of the changes that GAR has made has been in the brokerage agreements. Specifically, a lot of changes in the listing agreement. So instead of doing a whole long video on all of the changes they made to that agreement, I have been breaking it down into bite-sized segments, so to speak. So today what I want to talk about, I think you guys are really going to like this one. Is a change they made in the verbiage and the terminology regarding the term of the listing. So let me show you guys what I'm talking about, or tell you guys what I'm talking about. Under GAR Form F-101, which is the Exclusive Seller Brokerage Engagement Agreement, under the listing period, paragraph A2, and under paragraph A2, and further explained in the corresponding paragraphs B2 and B3, listen to what it says. The price at which the property shall be listed for sale is X amount of dollars, and you fill that in, and that's the list price. Now, here's the part they changed. The term of this listing agreement shall begin on the date of blank, and that's the starting date, and made available to the public on the date of blank, marketing commencement date, and shall continue through the date of whatever, that's the end date or the last date of the listing agreement, as the same may be extended by written agreement of the parties or as provided herein after. That is the listing period. And so in the corresponding paragraph, again, it talks about, no, it doesn't talk about that there. Anyway, so the difference is, what do you guys think? There is a difference between a listing date when you actually sign with your public seller and they become a client of your broker, versus another date, potentially, not always, but there could be another date when you actually start the marketing. So I teach a little bit more in depth on this in the class, as well as how that interacts with coming soon in your MLS listings, if they have that, FMLS and Georgia MLS and Metro Atlanta have that. So I am going to link below just that excerpt from the CE class that I teach on the 2021 GAR contract changes. So stay tuned. So beginning with the Exclusive Seller Brokerage Engagement Agreement. The first thing to bring to your attention is it has a brand new name. Now, this name change has been consistent. This is a universal change that GAR, Georgia Association of Realtors, has made throughout all of their forms. It got really confusing to the public as well as to a lot of agents the way we used the names. We would typically refer to the broker and the agent working with the seller as the listing agent or the listing broker, and we would refer to the agent and the broker working with the buyer as the selling agent and the selling broker. Well, that got really confusing because the buyer wasn't selling, but yet we use the term selling broker, selling agent to refer to the one working with the buyer. So to alleviate all of that confusion, in 2021, throughout all the forms, GAR has changed the labels for the brokers. The brokers and agents working with the seller is called the seller's broker or the seller's agent. The agent and the broker working with the buyer is now called, drum roll please, the buyer's agent or the buyer's broker. So that is going to alleviate a lot of confusion. So on the exclusive seller list, so instead of exclusive listing agreement, it is now called the exclusive seller brokerage engagement agreement. So the reason they do this, they use seller for the reason I just explained a minute ago, but you're going to see why they changed this too. The first major change they made. Check this out. Under paragraph A2, list price and listing period. So this is their paragraph here. And then we're going to get to marketing. So all of this is going to be described, further explained in the corresponding paragraph B. But let me go back to the PowerPoint and let me show you what they have done. I just want to show you where it is in the form. So paragraph A2, list price and listing period. Check this out, you guys. The price at which the property shall be listed for sale is X. That's the list price. That's not a change. The term of this agreement shall begin on the date of, and you fill in a date, that is the starting date. Then it says, and again, we're talking about a property. The property shall be made available to the public on the date of, here is a fill in the blank for another date. That is the marketing commencement date. So these two dates can be the same or they can be different. And shall continue through to the date of what? And that's the end date. You have to put an end date of your listing agreement. And they can be extended as provided for in the next section that we talk about. So again, what do you think? Why did they make this change? Well, they made this change to help you agents and brokers stay in compliance with license law. To work with the public seller as a client and for protection for your commission, broker commission regarding should something happen, should the seller sell that house prior to actually signing this. So here's the deal. The deal is we would have a lot of agents that would go meet with a seller. This seller loved that agent, wanted to hire that agent, wanted that agent to market and sell their house. The problem was the seller may have had a few things to do. They may have had some repair items to do. It might be during the time of year like now for the holidays. They might have family coming into town, school getting out, spring break, something where, yep, I know I want to sell, but I'm not quite ready to expose it to the public, to market it to the public yet. Well, before this change, you still wanted to create the client relationship with that seller. And the only way to do that is by signing this seller brokerage agreement, which creates the client relationship. There was not this distinction about starting the client relationship versus beginning the marketing prior to this change that GAR is making in 2021. So then it says further on in the agreement last year and the previous years that after you sign the agreement, it needs to begin being marketed within 48 hours. But your people needed time to, again, do repairs, or they had some family issue or something like that going on. So now GAR has allowed you to sign the listing, the brokerage agreement at one date to engage and solidify that client relationship. You could advise them. Before, if you didn't sign this, you did not have a client relationship with that public, and you really couldn't advise them what repairs they needed to do, what staging they needed to do, what anything they needed to do, because they weren't your client yet. So now you can create that client relationship now, help them, advise them, guide them through your expertise as a real estate agent, and then begin the marketing of their property at another date. So that way, because that also why I have on there, it protects your commission. A lot of times you would go on a listing appointment and they would have to do this, that, or the other. You wouldn't sign a listing agreement because it wasn't ready to start yet. And then a few weeks later, when they were ready, some other agent would have gotten there and they would have signed a listing agreement with another agent. So that so this protects your commission. So what are the time frames between these two? Well, there's nothing in stone about this. And you are also probably thinking, how does this interact with coming soon that we see marketed? Well, a lot of these changes, again, we have to coincide. We have to look at what documents are public assigning and the MLS listing rules. And a lot of this has to do with the NAR change that they made with the Clear Cooperation Rule 8.0. And basically, this is an FMLS rule, listing of properties. All improved and unimproved real estate listed for sale under an exclusive right to sell contract with a principal member must be listed with FMLS and entered into FMLS database within 48 hours after the listing is signed by the owner, except for weekends and federal holidays. Within 1 business day of marketing a property to the public, the listing broker must submit the listing to the MLS for cooperation with other MLS participants. Public marketing includes, but is not limited to, flyers, yard signs, digital marketing, public-facing websites, brokerage websites, digital communication marketing, multi-brokerage listing sharing networks, so forth and so on. And Georgia MLS also has the same rules. And again, if you are in part of Georgia with a different MLS service, I imagine that your MLS rules are the same. Again, these are changes that were made based on the NAR change in the Clear Cooperation Rule. So Georgia MLS also states that all residential listings must be entered into the system within 2 business days. Any exclusive right to sell is required to be entered into the listing database within 48 hours after obtaining necessary signatures. And the list date and expiration date must be supported. Any change must be reflected within 1 business day, and all listing must be accurate. So let's talk about the NAR rule. This is what NAR voted on. It's called Clear Cooperation 8.0. Within this verbiage is going to look just like FMLS and Georgia MLS. And again, I venture to guess the other MLS systems throughout Georgia. Within 1 business day of marketing a property to the public, the listing broker must submit the listing to the MLS for cooperation with other MLS participants. Public marketing includes the same thing I just read, but it's not limited to flyers displayed in windows, yard signs, digital marketing, public-facing websites, brokerage websites, IDX, VOW, digital communication, so forth and so on. There is a link. You can go to NAR's website and read more specifically information about the rule Clear Cooperation 8.0. So again, let's have a little discussion about coming soon. Have you guys seen the coming soon listings in your MLS services and on sign writers? Yep. Guess what? Your public has seen them too. So if you are going to list a coming soon listing, first of all, the seller must sign a brokerage agreement, and the property must at some point actually get listed. So again, back to the GAR form. Now we have a place, this time frame between when the listing agreement starts and there is a change for the marketing commencement date. So let's go back to the slideshow. A coming soon listing, I'm sorry, shall not be shown to any prospects until it's available to all. It is not a free look to your own clients. It is not a free look to your yard signs. It is not a free look to your brokerage clients. It cannot be shown to anybody until it's available to everybody. A coming soon listing refers to a property that is not available for showing or for sale until a later date. Coming soon can be a legitimate advertising technique, allowing the owners more time to complete repairs, pack, or otherwise prepare the property for a showing or sale. A legitimate coming soon listing should truly be unavailable for purchase or showing. The only way you can get a contract on this would be a totally blind offer. They cannot see the property. But again, you're going to have to list it anyway, even if you get a contract on it. Now, what about the unauthorized use of coming soon? Well, the unauthorized use of coming soon, it never gets listed. And that might be a license law violation. That might be an MLS membership violation. Biggie here, you guys, that might be a fair housing violation. And if you're a realtor, that might be a violation of the Realtor Code of Ethics. Sometimes coming soon advertising is used to circumvent the MLS, market the property to just a select group of people, or pressure a buyer to use the listing broker for the transaction, which not only breaches real estate professionals' ethical duties to clients, but also may violate license laws and consumer protection laws. So what about the proper use of coming soon? First of all, you must have a signed seller brokerage agreement before you ever market or advertise the property. And that includes sticking a sign in the yard. GREC license law, GREC rule 520-1-.092. Avoid violation of this GREC license law by misleading advertising, because it is advertising a property as being listed soon, when in fact, no listing agreement has been entered into, or you never list it in the MLS services. And there is another license law, Official Code Georgia Annotated, Title 43, Chapter 4025B2. You would want to avoid license law violation by placing a sign on any property, offering it for sale or rent without the written consent of the owner or the owner's authorized agent. Additionally, you may have appraisal issues. If a property sells before it's exposed on the open market, the appraiser might look at that and say that it was not exposed to the open market, therefore there were not appropriate market forces that would interact with the price. In other words, it's going to affect the appraisal. Additionally, if a broker is a member of an MLS, they have to adhere to the MLS rules, and we just went over those a couple slides ago. FMLS, the property is currently off market and will be I'm sorry, let me catch my breath a minute. For the FMLS coming soon status, and not all MLSs may have a coming soon status. The property is currently off the market and will be active within the next 21 days. So the question about the time frame between the when you engage in a client relationship with a client and market it, it depends on if you're putting it in MLS as coming soon. If so, you have a 21-day limit. Only FMLS members will be able to view coming soon listings. That doesn't mean view in person. That means view via the MLS listing. The coming soon status is only available at the beginning of the listing period, and once a listing is taken out of the coming soon status, it can't go back in. So does that mean you can bypass an agent and list it on FMLS without ever hitting the market? No. You must still have an exclusive listing agreement signed with a licensed FMLS member, real estate agent, to take advantage of this perk. If you sell the home before it goes live, you're still responsible to FMLS for fees and other agreed upon terms. And this is just the Georgia MLS rules, which is the same thing. Once you list it in Georgia MLS as coming soon, it must go live within 21 days. Now, One of the things also is your days on market will not accrue while it is in the coming soon status, and it does not get shot out to all of the online third-party websites. Like, it's not supposed to go out to Zillow, Trulia, Realtor.com, Redfin. It just shows to members of Georgia MLS. So what are the benefits? The benefits of a coming soon listing are to allow the seller time to make repairs, get ready, etc. Again, stage it or so forth. Again, as we've talked about, perhaps a good use during the holidays or school vacations. And it gives the listing agent more opportunity to get sign calls to generate interest if your broker allows. And it also, I need to add in here, it also allows the listing agent more time to get any marketing done. If you're going to have professional photos taken or drone photos. Drawbacks: your buyers are going to want to see the property and they may get upset when you're not allowed to show it. Again, limited exposure to market, so fewer offers and potentially a lower sale price for the seller. It puts agents in a position where they are not knowledgeable about the market, because you might have a public person that drives by, sees a coming soon sign in there, a rider on a sign, and yet your agent can't find it in the MLS service. The listing broker commission may not be protected if the seller brokerage agreement is not signed. And here's the big one, you guys. Again, it may be a fair housing violation if it is not exposed equally to all. And as we talked about, may not appraise for the market price. So that is a lot of information and a lot of tie-in with the new time frame, the new verbiage that GAR has put in there in the brokerage agreement, allowing for the client relationship to begin prior to the marketing. I just wanted to touch on the coming soon verbiage there. There is a question about new construction if you represent a builder. Again, builders, you're going to sign a listing agreement before marketing. The FMLS, well, depending on what MLS service you belong to, there are various rules about marketing new construction. For example, FMLS states that you do not have to market a property in the new, you do not have to market new construction in the FMLS listing service until it's at the drywall stage. So that tie-in has to do with the MLS agreement. All right. Just one more thing to address that I cut off the video from the CE class a little bit too soon. With respect to the same dates regarding the beginning of the brokerage agreement that creates the client relationship between the broker and the public seller, and this marketing commencement date. So one more thing is also in the 2021 GAR Seller Brokerage Agreement, Exclusive Seller Brokerage Agreement, Form F-101. It does, in the paragraph B, the corresponding paragraphs to the fill in the blanks in A, under the marketing section, under the MLS services of the marketing section, so paragraph B3B, it does go on to address this marketing commencement date. And what it says is the broker agrees to file this agreement with the above referenced multiple listing services within 1 business day of the marketing commencement date, which shall be the date the property is made available to the public. Marketing of the property to the public includes, but is not limited to, flyers displayed in windows, yard signs, digital marketing or public-facing websites, brokerage website displays including IDX and VOW, digital communications marketing, email blasts, and multi-brokerage listing sharing networks and applications available to the general public. Again, that's the same verbiage as the NAR Clear Cooperation 8.0. But what I want to bring to your attention is This states that the broker agrees to enter the listing in the MLS service within 1 day of the marketing agreement date. Again, that marketing agreement date is not necessarily the same date as the brokerage agreement date. So the brokerage agreement date is the date the client relationship starts between the broker and the client. The marketing commencement date is the date that the property goes live to the market or to the public to advertise it for sale. So just to kind of tie in the conversation with the coming soon, you don't have to list, even if there is a span of time between the time your seller signs the listing agreement and chooses to become your client, but they still need a little bit of time before marketing it. They want to get repairs done. They want to get it staged. They have family coming in for the holidays or anything like that. Whatever it is that they need to take care of. You don't have to, as an agent. Now, you need to check with your broker. Your broker might have a certain policy, but you do not have to list it in the MLS service as a coming soon listing. With this new provision in the 2021 GAR contract, it states, and there's commensurate changes in, at least in FMLS and Georgia MLS. Other MLSs I'm not familiar with. Basically, it states that it must be in the MLS service within 1 day after the marketing commencement date. So you can sign a listing agreement today, create the client relationship, advise the client what they need to do, how they need to stage it, what repairs, help them provide the courtesy, the ministerial act of giving them some contact information of vendors so they can choose the appropriate vendors, get work done, whatever. Then, and that can start now because you're in a client relationship. But then we have the marketing commencement date a couple of weeks from now, 3 weeks from now. It must go in the MLS service within 1 day of that marketing commencement date. And it can just go in the MLS service as a live listing. So again, you do not have to put a coming soon in the MLS service, even if a seller has to take care of some repair issues or staging issues or so forth and so on. So, what do you think? Love to hear your comments. So, I'm curious, what do y'all think? Do you guys like this change? I really, as a broker, like this change because it does create a difference between the time frame beginning which the public seller becomes your client, but they might have some issues to do before they actually want to start marketing it, and you don't want to not get their signature in case somebody in case they choose to list with another broker when they're ready to go. So love to hear your comments below, your thoughts. Comment below. Please like and share this video, and thank you so much. Stay tuned for more. Dana Sparks, broker of Maximum One Greater Atlanta Realtors, satisfying your needs with service, innovation, and education.